Hi, everybody. Welcome. And uh, welcome to Happy Friday night since we're getting together on a Friday. Um, I'm, I'm, I'm anxious to catch up with everybody. I've missed you all and bring you up to date on all of the stuff that's been going on as to the reasons why I didn't see you for the last couple of weeks. So, just before our Wednesday night 2 weeks ago, I started coming down with the crud and just was not feeling up to having a live. True to form, my husband got over it in about 5 days, and it's taken me 3 weeks. So, but I'm finally feeling better. During that time, we went down to Southern California and spent Thanksgiving with my daughter, son in law, and son in law's family. And so there was some travel involved during that time. But now we're back safe and sound. We were fortunate enough. Central Oregon has been under an, a weather inversion, which causes us to have freezing fog. And so we were fortunate to get back into town on Tuesday. But my daughter hasn't made it back yet because she couldn't get in because of the fog at the airport. So we're still working through all that stuff as well. But boy, do we have a lot to talk about. We have a lot of things that have happened in the last weeks or so in true crime. Um, I couldn't do our regularly scheduled time because I had book signings. So that was really exciting. They were here in Central Oregon, but it was great fun. So we have much to talk about and a little to talk about, a lot of different cases. But I want to open up with our favorite case, Lori Vallow. She, for those of you who might not be still following her, she is in Arizona awaiting trial on on two cases. One having to do with conspiracy to murder Charles Vallow, and the other is a conspiracy to murder Brandon Boudreaux. Brandon Boudreaux was her niece Melanie Boudreaux's husband, then ex-husband, and Alex Cox attempted to murder him for his life insurance. Um, Alex Cox, who was not the best shot in the world, apparently, because he also missed when he shot at Tammy Daybell, thank goodness, missed his shot at Brandon Boudreaux. So she's in Arizona waiting trial. She's had a couple of different sets of public defender lawyers. And the last ones, the first group, filed a motion with the court saying that they had concerns about her competency again. So the judge ordered a competency evaluation. Then, when this and the first group of lawyers asked to withdraw from the case, then she was appointed a second group of court-appointed attorneys, and they, after having talked with Lori, said they wanted to withdraw the competency motion. And they informed the court that Lori wants to represent herself. She does not want any more lawyers. And the judge was concerned that there were questions about her competency, and he didn't want to agree for her to represent herself if there were questions about whether or not she was competent. So, on his own motion, he continued to ask for a competency evaluation. She had two separate evaluations by two different evaluators, both of whom said she's competent, as I expected. And so she was in court this morning where she had a conversation, a colloquy with the judge on whether or not she understood the consequences of representing herself and whether or not she understood under what circumstances she could go forward. She was very lucid and very competent in her conversation with the judge. And the judge said she would be allowed to represent herself, but he was going to um, leave the attorneys who are on the case right now on with her as advisory counsel. So she is going to move forward herself. She's already prepared a response to a state's motion on discovery, which she filed with the court today, and she is going to go forward representing herself. That may be worth the price of admission. So it will be very interesting to see how she goes forward. Um, her appeal is still being delayed because of transcripts. Sorry, still got a runny nose. Because of some of the transcripts. Some transcripts of jury selection were just filed, and the appellate lawyer for her in Idaho has asked now 4 times for the deadline to be put off for when they have to have their opening brief in. And the most recent decision was that the deadline was extended until December 26th. So they don't have a lot of time to get right on that appeal. I expect they're going to ask for more time, but the appeals court does sort of get to the point where they say, we're not going to give you any more time. So the judge who was hearing the competency motion said she was competent yesterday. He then scheduled a status conference today before the judge that will be hearing her case. So, and they set a March of 2025 trial date. I'm not positive of the date. I'm going to have to look that back up because I thought I had written it down and I didn't. So there also were some outstanding motions pending in the Brian Kohberger case, the other Idaho case that we're all following. That is the University of Idaho college students that were killed in their off-campus apartment. There were quite a few motions that were filed. There were quite a few motions having to do with discovery, and also motions to suppress. Now, Ann Taylor has filed motions to suppress having to do with genetic information. They want Amazon. They've filed for motions to suppress anything discovered through Amazon, Apple, his apartment, the cell phone, Google. The memos that accompany these motions have all been sealed, so we can't see what the basis is for those motions. The court denied all of the motions having to do with the death penalty, which is not a surprise. That was expected. Death penalty attorneys always file these motions challenging the death penalty in hopes that there will at some point be some amassing of a body of law that will justify throwing out the death penalty. But for the most part, we expect that those are going to be denied. They also filed a Franks motion. Now, if you remember from Delphi what a Franks motion is, a Franks motion challenges the probable cause affidavit that accompanies indictments. And so they filed a challenge to the probable cause affidavit. They submitted it. It, first of all, exceeded the page limit, and then was accompanied by somewhere around 1,000 pages of exhibits to support the Franks motion. The judge complained that the defense didn't do enough to identify where within this voluminous trial exhibit the information was that they were pointing to justify their motion. So the judge has sent it back to them and said, you need to specifically cite where within this huge exhibit is the information that actually supports the point that you're making. So they have a pretty short time, I think maybe 10 days, to turn that around and get it back to the judge. The judge denied a motion from the state. The state asked the judge to throw out the motion because it exceeded the standard page limits. The judge refused to do that, saying that because of the complexity of the case and the volume of discovery, that he would have granted a request to exceed the page limit had the defense asked for it. So to sort of circumvent granting the motion, having them then file the motion to exceed the page limit and refile it, the judge said he would have granted it, and so he denied their request to dismiss the motion based on the fact that they exceeded the standard page limit. That is about all that's going on right now. We are certainly waiting for some additional decisions, for the court to make some additional decisions on motions that have been taken under advisement, but we haven't gotten those back yet. Most of those have to do with the motions to suppress. The last I heard, that motion to suppress hearing is going to be sealed, and it won't be televised. Now, that could change, but what we're hearing now is that the judge granted the motion to seal all of the hearing memos and all of the supporting information about the motions to suppress. And if the judge is going to seal those, then it wouldn't make any sense for them to be presented in public in a live stream. Forgive me, I'm still a little bit froggy. So the next thing I wanted to talk about is Karen Reed. Recently, the state asked the court to order, in many states, in order to get discovery out of a third party, the court has to sign an order. And so the state came, and the new attorney who's been added to the state's team came to the court and asked the court for motions allowing them to get Karen Reed's father's cell phone records. Now, here's their argument. Their argument is that they believe that Karen Reed made a phone call to her parents somewhere around 1:30 in the morning. That would have been about the time, if Karen Reed hit John O'Keefe with her car, that occurred. Now, there's no record of that on her phone, and they want to get parents' phones in order to support what they believe was a middle of the night phone call. The only call on Karen Reed's phone is at 6:30, which would have been around the time that John O'Keefe's body was found. So the state says this is nothing but a fishing expedition. There's no evidence to believe this phone call ever occurred. They just think it did, and they want to go fishing. The judge has not made a decision yet on whether to allow that. The other thing that the state put the Commonwealth put the court and the defense on notice was that they planned to challenge the qualifications of the dog bite expert. Now, if you remember Karen Reed's trial, what came out was this woman was an ER doctor who had seen hundreds of dog bites and who came to court and said that she believed that the injuries on John O'Keefe's arm resembled an attack from a dog, both scratches from the dog's nails as well as a bite mark. So the defense called her and qualified her as an expert. Now the state is saying, wait a minute, we want to be sure, we want to test her qualifications under what's called Daubert standard. That's a federal case. And it controls what standard experts are put to before they can testify as experts, and what standard scientific information is put to. And we've talked a lot about the fact that there are a lot of areas of forensic science that as our technology improves, we realize is not all that reliable. For example, we've talked at length about the gun, the unspent bullet that was found at the scene in the Delphi murders, and whether or not the technology that compares bullets that have been cycled through a gun but are not fired, we've talked about that as being kind of questionable science. So anytime there is a scientific method that is presented to the court by an expert, it has to meet the Daubert standard. And so I just wanted to talk a little bit about what that test is, what the judge has to consider when deciding whether or not this person or this technology and science is reliable expert testimony. So the first thing that the judge has to do is ask, can the theory be objectively tested? So is there a method to test this theory? The second is, has this theory been peer reviewed? So reviewed by other experts. The third thing is, what are the potential rates of error? And finally, what standards and controls are in place, and whether or not the theory has general acceptance among the academic community. I really think that the defense is going to have a hard time meeting that Daubert standard as it applies to this woman who claims to be a dog bite expert. But that hearing will be coming up in the next couple of weeks, along with hearings on some other Rule 17, which is discovery motions. The judge did order a local news outlet to give up their notes and raw footage having to do with interviews that were done with Karen Reed and her family. The judge did say that those were relevant and that the state had a right to get those. So Karen Reed and her family gave a couple of interviews to local media, and the defense was fighting having local media be able to, the state be able to access their notes and their unedited footage of those interviews. So we also had news from Susan Smith. For those of you who may not be familiar with the case, Susan Smith has been in prison for 30 years for killing her children by leaving them in her car and driving the car into the lake. she was eligible for parole, and this was her very first parole hearing. She was eligible for parole after 30 years. Now, what happens is parole doesn't get automatically granted when you hit that magic number. What happens is then the parole board reviews your case. They review how you behaved while you've been in custody. They review the facts of the case. They look at the plan for where this person might go if they were paroled. And they also look at um, any reports from any other experts, psychologists, um, and they also take into account the wishes of the victim's family. In Susan Smith's case, her former husband, the father of the two little boys, vehemently opposed her release. There were a couple of people who appeared to be religious leaders or pastoral sorts of counselors who have been exchanging letters with Susan, who came and spoke on her behalf. But for the most part, most of the people who appeared at the parole hearing were very much opposed to her being released. And in a very quick decision, the parole board unanimously denied her parole. So she can reapply for parole again every 2 years. So she can reapply again in 2 years. If denied, she can continue to apply every 2 years. A lot went on in the last couple of weeks. We had Laken Riley, the murder of Laken Riley by his Jose Ibarra. This case got a tremendous amount of publicity because Jose Ibarra was an illegal immigrant. He was in the country illegally. And there's some indication that he was wanted for murder in his country of origin as well, and may possibly be a serial killer. The interesting part about this hearing, this trial, was that it was a bench trial and not a jury trial. So I wanted to take this opportunity to talk a little bit about why we might do a bench trial versus a jury trial. So in the normal course of things, you're in a courtroom, there is a jury, and the jury hears the evidence and decides the facts. They decide what evidence they believe, what they don't believe, what applies, what doesn't apply, and they are the ultimate finder of fact. Under that scenario, the judge really directs traffic in the courtroom. The judge decides evidentiary issues, whether or not something comes in under the rules of evidence, and sort of keeps the courtroom running and on task. However, there is always in a criminal case an option for a criminal defendant to waive their right to a jury and to have a judge decide a case rather than the jury. So under what circumstances would you not want a jury to decide your case? There are several reasons why you might want a bench trial. One is because you have a client who, for whatever reason, is decidedly unlikable, does not present well in front of a jury, can't control their face, can't control themselves, any of those things, because you don't want that person to have the jury to have that impression of that person. And it's much more likely that a judge and decide, sorry, I'm having a little glitch there, and decide the case based on the facts and the law. So that's one reason. The other reason might be because you have a client who has a difficult criminal history, and it's possible that that criminal history is going to come out to the jury. The state's certainly going to try and get that criminal history in front of the jury, and you are concerned that the jury may not be able to set aside what they know about some kind of prior bad act from the current case. So, for example, when we heard the Vallow Daybell case, there was a great deal of information that came in about the crimes that happened in Arizona. If the defense was concerned that that information was so damaging to the defendant that it was going to inflame the jury or make the jury find against your client, then you might want to have a judge decide that, because once again, it's more likely that a judge, a seasoned judge, is not going to jump to the emotional conclusion that a jury might. So it seems to me that is why Jose Ibarra opted for a bench trial. The judge went through all of his reasoning, was very thoughtful, and in the end found him guilty, and he was sentenced to life without parole. Laken Riley was a young college student. She was out for a run. She was a nursing student. She was dearly beloved, and quite a few of her friends and family gave some really moving statements, victim statements for sentencing. So, and then we had Chloe Driver. This, once again, was a pretty interesting case. It was not your run-of-the-mill case. She was a young woman who was involved in a group of the case had a bit of a Daybell overtone in that the father of the victim was her boyfriend, and he was thought to be something of a religious prophet, and he embraced polygamy, so he had two other wives along with Chloe. Chloe was the only one that had any children. They had this little girl. She was quite young, I think 18 months. And Chloe locked herself in a bedroom and stabbed the baby to death. And it was a very clear, there was no question that she did it. The question was whether or not she was not guilty by reason of insanity. However, the state where she was tried, and it's escaping me now, but has a statute similar to my home state of Oregon, where it is not the verdict is not guilty by reason of insanity. It is guilty but insane. And maybe it sounds like there's not much difference, but there is a really critical distinction in that, because a not guilty by reason of insanity means that you are not guilty, that you are found to be innocent of the crime because you were insane at the time that it was committed. That Georgia, thank you, Amy. So that is vastly different from a verdict of guilty but insane, because the outcome can be different. In a state with a guilty but insane verdict, once that person is adjudicated guilty but insane, they then become They come under the commitment to the state mental hospital, and they are committed there until they are found to be not insane anymore. At that point, then the judge must decide what the sentence will be based on all of the circumstances. So, guilty but insane, if that person is restored to sanity, there is an opportunity that the court may still impose a sentence. Typically, what happens in that case, in these kind of cases where somebody is found to be guilty but insane, is that they're committed under the supervision of, in Oregon, it's the Psychiatric Security Board. And that PSRB monitors anyone who is guilty but insane, has been adjudicated of a crime. And they follow that person's progress. And if there comes a point that the experts say this person is, for legal intents, sane, then the PSRB reports back to the court. This person no longer needs the supervision of the Psychiatric Security Board. Now the judge needs to decide whether or not there's going to be a further sanction, and if so, what it'll be. Often what happens in that circumstance is the court will order that the person be essentially furloughed from custody into some sort of transitional housing and on some sort of very rigorous and lengthy parole after that furlough process. So, so in Chloe Driver's case, she was adjudged to be guilty but insane by a jury, and her sentencing is set for the 12th of December. So at that point, there's no question that the judge will be committing her for some period of time for mental health treatment. And then the judge will later have to decide whether or not there'll be additional sentences. So there is a real important legal distinction between not guilty by reason of insanity and guilty but insane. Where in a not guilty by reason of insanity, that person, their criminal history will show that they were acquitted of the charge. In a guilty but insane verdict, the person would show that they were convicted of the crime. It's only the punishment that is up for consideration. So hopefully that explains a little bit about what happened with Chloe Driver. I saw a funny comment as I was looking through stuff to talk about tonight, and one was from P. Diddy. Now, you all know Sean Diddy Combs, rap artist, was arrested and is being held on RICO and trafficking, human trafficking charges, and he's in really deep trouble. Of course, he's got really, the best attorneys money can buy, and they're making every argument they can to get him out of custody. He's been denied bail 3 times now. It's very unlikely that the court is ever going to grant bail for P. Diddy. But now he's complaining that the feds are spying on him in his cell. And I had to laugh because we have seen repeatedly that there is absolutely no privacy in jail or in prison, that the prison and the jail can record every conversation. We saw that in the Delphi case, where we saw recordings of Richard Allen, and his every movement was recorded. And the same for P. Diddy. I have no doubt that every movement of his and every communication he has with anyone is recorded. And every piece of paper that goes into his cell is scrutinized. And his lawyers keep complaining that they're seizing his legal materials, but the judge was sort of skeptical about how much of the information that the state had acquired was really legal mail from his attorneys, and how much of it was just stuff, pages of notes that he'd written legal across the top of. So um, I hate to break it to Sean Diddy, but there is no privacy in jail. And so nobody's spying on him any more than anybody else. They have a right to follow and record his every movement. Um, there is a kind of an interesting case going on right now in New York. The defendant is Daniel Penny, and it is a self-defense case because he put a rowdy subway passenger who was acting in a threatening way in a chokehold, and the person died. What's interesting is that the jury deadlocked on count one, which was second-degree manslaughter, I think. And after 4 days of deliberation, the judge gave the Allen charge, which is basically the dynamite charge. You're the best people to do this. Go back and keep deliberating. And it took them a very short time to come back and say, we are hopelessly deadlocked on count one. But the fascinating part about it is that the way that the jury instructions were read, they could not go on to consider a lesser included offense unless they had decided count one, and they're deadlocked. So unless they could say, we don't believe he's guilty on count one, then they could go on to whether or not he was guilty of negligent homicide in count two. So the judge took a look at it and was sort of skeptical about whether or not he could. Well, he essentially said, I since you're deadlocked on, keep getting these little glitches where my computer seems to be spooling. So hopefully you're not getting it on your end. So the judge said, I cannot direct the jury, ignore count one and move on to count two because you're deadlocked on count one. So the prosecution came back and said, we will stipulate to an acquittal on count one and direct the jury to move on to count two. That's pretty dangerous because if the jury comes back and says we're deadlocked, period, then they don't have the ability to go back and retry this guy on count one. They only would be able to go back and retry the counts where the court finds that they were deadlocked. The act of dismissing that count means they can't go back and redo it. So that's kind of fascinating. The judge gave the jury the weekend off, said, go get some rest, think about it, and come back on Monday prepared to continue deliberation on the remaining counts. So we'll see what happens. There has been a very large public groundswell that this should be a not guilty verdict because this person was in fear for themselves and for the other passengers on the subway train because this guy was violent and dangerous. So that will be something to watch for next week. Then we have the New York shooting of the CEO of insurance company, United Insurance, I think, and United Healthcare. And he was in New York for an investor conference. He lives in Wisconsin, I think, and but was in town for an investor conference, and a person was lying in wait outside the hotel where the conference was going on. And as he walked up to go into the conference, the guy shot him at least twice and may have been more. A lot of people have been speculating about whether or not this was some sort of professional hit. This guy is the CEO of this huge major insurance corporation. And there was some suggestion by his widow that there had been some threats before. Um, but I listened today to Ian Runkle, who is Runkle in the Bailey, I think it is. He is a Canadian lawyer, and he's very interesting because Canadian law about firearms is very different than American law, and he specializes in criminal and particularly in firearm law. He's very accomplished uh, handler of firearms, a hunter, and so he had some great observations about both what the gun was and why he felt that this person was not a professional. There's no question that it probably was planned. The person who carried it out planned to shoot this person, but there was enough sort of fumbling and blundering to make it doubtful that it was any sort of a professional, what we think of as in the movies as a professional hit. So the shooter is still at large, and law enforcement is continuing to investigate and to try and track this person down. They do have some video footage. For the most part, this person wore a surgical mask or a COVID mask and a hood and was pretty well disguised. But he stayed at a youth hostel nearby where the murder happened. And at one point, the woman behind the counter, who was sort of flirting with him, told him that she needed him to take his mask down so she could see his complete face. And he did that. And they have that on video footage. So they do have images of his full face. And they're hoping that facial recognition software and widely publicizing the photo may get some hits. It appears that he came in on the bus. The bus may have originated in Atlanta, Georgia, but there was no indication where along the bus's route he got on the bus. So, and it also appears that he was in New York for some period of time before this. So he was there planning and getting ready, apparently. He ran down an alley, he got on an e-bike and disappeared into Central Park. And so he has not been found. So they're continuing to investigate that one. Some really interesting information came out in the Kentucky case where the sheriff walked into the judge's chambers and shot and killed the judge. This is a case, Sheriff Mickey Steins was the elected sheriff, and he and Judge Mullins were longtime friends and associates. And Sheriff Mickey Steins walked into the judge's chambers and killed him. There is some new information that's surfaced that sort of begins to paint a different picture. So initially, what they knew was that the sheriff went into the judge's chambers. At one point, the judge gives him his telephone, and from the judge's phone, the sheriff attempts to call his daughter. Initially, people wondered, well, was her number in in the judge's phone? Was there something untoward going on between the judge and this minor teenage daughter? But that doesn't appear to be the case. First of all, law enforcement said that when the judge gave the sheriff his phone, the sheriff put in his daughter's phone number. He wasn't calling up a past call or a call log. Um, but some other things have come to light that are pretty fascinating. The sheriff was, of course, in addition to supervising officers in the field, the sheriff is always responsible for the county jail. So this sheriff had been responsible for the leadership and the management of the county jail. There was a county corrections officer, a police officer, a county deputy, who was accused of using this judge's chambers as a place to meet jail inmates because he was offering them release without an ankle monitor if they would have sex with him. So this all came to light. One of his victims filed a civil suit, a civil rights action against him, and named the sheriff as liable because it was the sheriff's duty to supervise the members of the sheriff's staff and provide leadership. There's no suggestion that the sheriff was in any way involved in any of these shenanigans. But just a day or so ago, a court TV producer turned up a recording of a deposition of a law enforcement interview of the victim in that case. She reports that the deputy who was trading bail for favors had recorded several people, had recorded several other women who were inmates in the judge's chambers, and that on one of those recordings, it showed the judge having sex with one of these inmates in return for bail. That puts this case on a completely different footing. I mean, it is very possible that this sheriff found out that this judge was in on this scheme with his deputy, and this sheriff, for some reason, decided to take justice into his own hands. But it definitely puts the case in a completely different light. From the beginning, the sheriff's attorneys have said there is a heat of passion defense. Now, not all states recognize this defense, but there is a defense in some states where it's sort of like the spouse that walks in on their spouse with another person and reacts, or it's a very reactionary kind of a defense, saying this person reacted to the situation before they had time to think about, I probably shouldn't do that. And his attorneys have suggested at several junctures and several interviews where they have suggested that that potentially there's a justification defense. So, well, and the next one I wanted to talk about, there are two that I want to talk about sentencing on that were sort of jaw-dropping. The first one is our friend Sarah Boon. So Sarah Boon was sentenced, and at her sentencing, she got on the witness stand and made her allocution, her statement about what happened, and asking the court to be lenient with her. And the judge, we've seen Judge Kranick throughout this case be very patient with Sarah Boon. And he continued to be very patient with her as she sat on the stand and essentially blamed the victim once again, claimed herself to be the battered spouse, the victim, that she was the victim, and that it in fact was George Torres's fault that all of this happened. And the judge allowed her to do that. And when it was all over, he very quietly and very straightforwardly sentenced her to life in prison. She does have the possibility of parole. I believe it was after 30 years. But he certainly did not find anything that she said particularly compelling, or that anything she said moved the needle on his opinion of where she belonged. Likewise, we have the case of Melody Ferris. For those of you who were following it, it was called the burn pile murder because the victim's body was found burned in the burn pile on a rural piece of property. The victim, Gary Ferris, was he was a well-established and fairly well-regarded attorney. He was married to Melody Ferris. They had 4 children. And the property they lived on was sort of a gentleman's farm. It was like a hobby farm. And there was no question that over the years, their relationship had been strained. She'd had affairs. He'd had an affair. I mean, it was certainly not a happy marriage at all. One of their sons, the father, the victim, had hired him to help out around this hobby farm because it was getting to be too much for the 2 parents to handle. And she very consistently has blamed her son and said it was not her, but her son who murdered the victim. And during her allocution at sentencing, she once again confronted him, made eye contact with him in the courtroom, and accused him of being the person who had murdered his father. Those 2 statements at sentencing were both definitely worth watching if you haven't seen them, because they're really troubling. And the last one that I wanted to bring up was Alec Baldwin, just in case you thought that the Baldwin case had not was over. It is not. And that is because Carrie Morrissey, who was the special prosecutor on the case, keeps filing appeals to the judge's decision to dismiss the case with prejudice. So initially, she filed a motion with the court for the court to reconsider. The judge said, not going to happen. Then she filed a notice of appeal saying that she wanted to appeal the judge's ruling of her denial of the motion to reconsider. A lot of people have asked, what the heck is Carrie Morrissey doing? Because the judge was very specific about the reasons why she dismissed the case with prejudice, that this was not the first discovery violation, although it was the most egregious of the discovery violations, and that it justified her dismissing the case with prejudice, meaning that the state could not refile it. A lot of people have wondered why Carrie Morrissey won't let this go. I think it's because there are bar complaints, and there are professional responsibility complaints, and there are malpractice complaints up the wazoo having to do with Carrie Morrissey. And she thinks that her only chance of getting out of those problems is going to be if the appeals court reverses the trial court's ruling having to do with the dismissal. So I don't think there's any reason other than the fact that she's trying to mitigate the consequences of what she did. And so I think that's the whole reason why she keeps filing stuff and asking the appeals court to overturn the trial judge. So that is the last of my recaps, but I'm sure that there are other things that you all want to talk about that I haven't gotten to or that you had questions about. So we're going to throw it open to questions and see what's on your mind. And I'm going to try and hang in there as long as I can, as long as my voice holds out. So, Jen, what have you got for me? Oh, Sharon Hutchinson, thank you. In Florida, life is life, no parole for Sarah. I couldn't remember because I thought I might be mixing that up with Melody Ferris, who was eligible for parole after 30 years. Now she's in her mid 60s, so essentially it's a life sentence. And the judge did make at least one of the other criminal convictions consecutive to her life sentence. So that would be, I think I figured it would be an additional 5 years before she would be eligible for parole. So, but thank you for that because I want to be accurate. So, what else you got? Hi, Carolyn 008. So excited I made the live, 2 p.m. Saturday here on the East Coast of Australia. Well, thank you for joining us. And I'm glad you made a live tonight too. And hello to you in beautiful Australia, where it is summer. And I'm envious because we have had ice fog for the last several days here in Central Oregon. What that means is the fog rolls in and lays, and the humidity from the fog, the mist from the fog, then freezes on everything. So everything is covered in white. It looks like a winter wonderland. I'll try and post some photos on our Facebook group, The Good Lori. But it's beautiful. But after about the third day, everybody's done with it. So we had a little blue sky today, and that made everybody a little more hopeful that we're going to get the fog out of here because it's been hanging around for days and days. And you know what that can do to your attitude. So I'm envious of people who are celebrating Christmas during the summer in Australia. I visited Australia many years ago now. Was a delayed honeymoon for my husband and I in, dare I say, 1988. And we visited the entire eastern coast from Melbourne all the way up to Cairns. And spent about 6 weeks in Australia, and it was amazing. We had a boat in the Whitsunday Islands and did some diving on the Barrier Reef, which is an experience not to be missed. And so it was really fab. So welcome from Australia. What else you got for us, Jen? Yes, hi, Carol. I did hear Sarah's statement, and it was horrifying. I mean, she certainly, definitely still takes the position that she is the victim, that Jose, or that George, getting some of my people confused, that George was the aggressor and that it was all his fault. That she zipped him in the suitcase. So she was clearly unrepentant. And I think that Judge Kranick finally just thought, nothing I say is going to get through to this woman. I'm not going to waste my breath. And I am not going to give her anything to complain about. He was extremely cautious about making sure that at every turn she was satisfied with her lawyers, but that will not keep her from filing every kind of appeal possible, including appeals having to do with her lawyers. So, yeah, it was hard to listen to her literally taking absolutely no responsibility for her part in any of it, that it was all George's fault. So, hi, Ladybug Lady. This is a good question. If Lori Vallow does represent herself, can she call anyone as a witness, for example, Chad or Melanie? Yes, she can. She will have the power to subpoena people to appear in court as witnesses. And yes, she will be able to um, call Chad as a witness. Now, that's going to have some hoops to jump through because he's on death row in Idaho. And so the judge will have to determine under what circumstances he could appear, but she could very easily attempt to have him subpoenaed and brought over to Arizona to testify. And it would not be the first time that I have seen a case where someone represented themselves for the sole purpose of being able to bring people in as witnesses that their their attorney wouldn't call. So that may very well be. I mean, Ted Bundy represented himself so that he could propose to a woman that he'd met in court. And under the law of the state where that occurred, I want to say it was Utah. Um, if they claimed in open court that they were married, they were married. So he used that court proceeding to propose and marry a woman. Um, and I know of other cases where people have represented themselves so that they could get their ex on the stand or their former boss on the stand when there were witnesses that the attorneys wouldn't necessarily call as witnesses, that wouldn't be able to justify it. Yeah. So it's very possible. Do I see hi from Tillamook? I see burger-ish, I think that is, or burger fish. That's more appropriate for Tillamook, which is down on the Oregon coast, where they have the best cows that make the best ice cream in the world. We're staying warm. We're very fortunate to be quite snug, but it has been a taxing few days with a lot of frost, and my daughter hasn't been able to get back in. So I have been going over and taking care of her kitty for her while she's away. But she's hoping to get home real soon. So thank you. Nice to hear from you from Tillamook. One of my favorite places is a lovely Airbnb in Oceanside, which is right outside of Tillamook. Teresa Moore, no question, just glad to see you. Well, I'm glad to see you all too. I felt bad about not being able to go live. Um, Thanksgiving just wasn't feasible the Wednesday before Thanksgiving because I was visiting somebody else and we were in the throes of making pies and doing all sorts of things to get ready for a good sized crowd for dinner. And then last week, I didn't have a voice, even if I had wanted to get on. I just didn't have a voice available. So, but feeling better, finally getting over the sinus infection and the bronchitis and all of that stuff. So I'm back to full strength. So, but thanks for missing me. I appreciate that there are folks out there who miss it when we don't talk. Jane Blackbird. In the driver case, the witness Jason was allowed to ramble on about his disgusting beliefs. Isn't there a narrative objection that can be made or unresponsive to the question? Good question. And yes, I didn't watch all of that trial, but I did watch some of it. And yes, he was allowed to ramble on about his beliefs and his relationships, and it was allowed to go on for quite a long time. I think the defense didn't object to it because it supported their position that that Chloe had been um, pushed to the limit in the stresses of this odd relationship and this odd religious philosophy and the level of control that Z, who was the father of the child, was exerting on everybody that was involved. I don't know why the state didn't object more to that sort of narrative form of um, testimony, other than that he was their witness. Um, but there should have been probably more interruptions. There were some instances where one side or the other interrupted, and sort of um, a lot more of those objections had to do with whether or not what he was saying was relevant to the facts of the case. But I could see why the defense wanted him to go on about all their weird beliefs and all of that, similar to the Vallow case. I mean, defense wants the jury to know about the strange beliefs and the pressure that it put on Chloe, the control that he was exerting over her. So, you know, sometimes lawyers don't object when evidence is clearly objectionable because it helps your case. If what's coming in helps your case, you're not going to jump up and say, "Objection, Your Honor, hearsay." You're going to let that hearsay roll right in, because it helps you. So um, the judge does not object to evidence without one or the other of the lawyers doing so. So the judge is just there calling strikes and balls. And if neither attorney objects, then that evidence is going to come in, even if it's coming in, you know, in a problematic way. So, good question for you, trial watchers. Hi, Ladybug again. I have concerns that Charles Vallow will not get justice with Lori representing herself. Do you think we can get justice? I believe that the prosecution is not going to let this prosecution go off the rails, with Lori representing herself. Um, there's no question that having a pro se defendant, somebody who's representing themselves in a criminal trial, is problematic from the prosecution standpoint. It's, you're having to raise objections and stay on top of things that you might not otherwise have to stay on top of if you have a lawyer on the other side of the case. So it's definitely a more elaborate preparation, and it's definitely more of a courtroom dance. But I do not see the prosecutors losing control of the case because Lori's representing herself. And I did not get the impression from the judge who has been assigned to the case that the judge was going to put up with any of that kind of nonsense either. So I think there's a very good chance that Charles Vallow will get, and Brandon will get justice, even with Lori representing herself. Um, and, I think she thinks she knows more than she does, but we'll see. She will have advisory counsel, and they will be available to help her chart some of those potential evidentiary issues and be able to help her, advise her, but she has to use them. She's not required to reach out and use them just because they've been appointed. So, hi, Carolyn. What is the learning curve for someone representing themselves? Steep, very steep. Now, she today said to the judge, I have been through 2 jury trials and a criminal bench trial, plus the family law cases that she was involved in. And she believes that she can represent herself. I don't know where that third trial came from, but obviously she was involved in the two with her and with Chad. We don't know how much of Chad's case she saw because she was not there as a witness, and so we don't know for sure. But we do know that she sat through her own trial, and she represented to the judge that she was prepared to represent herself. Um, and the judge was very clear. Do you understand that you have these lawyers who went to school for somewhere around 8 years of schooling and have somewhere around 30 years of experience trying cases between them? You understand that they have more ability than you do. And she said, yes, she understood that, but she was confident that she could represent herself. I think this comes from the fact that they're not um, they are not acquiescing, they're not giving in to her the way that her Idaho lawyers did. I think that her Idaho lawyers really toed the mark when it came to what she told them she wanted and didn't want. And I think that these lawyers have been less inclined to do that. And the Arizona lawyers have been less inclined to make arguments that probably are not helpful to the case. Lori believes that there are arguments to be made that her lawyers don't seem to feel that they can make with a straight face. And if you got to put a bag over your head to go to court and make an argument, it's probably not going to win the day. So um, it appears that her lawyers are trying to do their best for her, but ultimately she is the one who is responsible for herself if she opts to represent herself. The judge was very clear with her that at any time she could bring her advisory council back into the case, but that they would not be able to go back and undo any damage that she'd already done, that they wouldn't be able to go back and sort of erase and redo anything. And that if she brought them back in, the judge was not going to allow it to be, I want my lawyers, I want to represent myself, I want my lawyers. She couldn't go back and forth. If she brings the lawyers back in, she should anticipate they will finish the case. So the judge was very clear about his expectations of her representation. And she was very adamant that she wanted to represent herself, that she had already started preparing documents that were the responses to some of the state's discovery motions. And she filed them with the court as today. So I think she believes she is charging full speed ahead. I don't think that anybody really knows what it takes to put on a criminal trial until you've actually done it. Now, Lori can say, I've been through these number of criminal trials, but it hits different when you're the person who is having to listen to a witness, figure out where, what the witness is testifying to, find the part of the deposition that you can use to impeach that person, all the while making sure all your exhibits get marked and all of those other things. John Pryor had an almost insurmountable job putting that Chad Daybell's case on alone. He did as well as anybody could expect him to do, but that it's a tough, it's a hard thing to do, and the more complex the case, the harder it is. I mean, a straightforward DUI or check kiting or some sort of uh, robbery is straightforward enough that one lawyer can generally keep up with it in court. But you get this very complex court case where you've got terabytes of discovery trying to find um, Garth's statement to law enforcement in thousands of pages when Garth is on the stand is a tall order, and it's tough to do. And there's a lot of things that there are a lot of an attorney can anticipate a lot of what is going to come out on direct, but there are always things that come out on direct that you don't anticipate. But you know that you have a way to impeach the witness about that piece of information. The question is, how do you retrieve it? And while you are sitting at counsel table, surrounded by exhibits, trying to keep your exhibit list, trying in the case of Daybell, to listen to your client, listen to the witness, and still figure out where in the discovery that impeachment evidence is. So it's a tall order, and underestimating the learning curve. I'm sure she is. Well, we're having little glitches tonight. Any more questions for us? Hi, Teresa. Do I think Lori Vallow will be as bad as Daryl Brooks? Absolutely not, because Lori is all about how appearances and how she looks. She wants to look like she's the lawyer and she has it all under control. Daryl Brooks was so prone to outbursts and I mean, it made for great courtroom theatrics, but it didn't make for a good trial for him. So I don't believe that Lori will be anything like him. If anything, she will be cool as a cucumber because she wants to appear that she has it all together and knows where she put it. That doesn't mean there aren't going to be some really interesting uh, interludes in a Vallow case where she is representing herself, but I think she will want to appear uh, absolutely in control and absolutely competent. Let's take a couple more questions and then we'll wrap up for the evening. Poor Lori's not getting her way. I have a feeling Lori won't present a case or question any witnesses. No, I think she will present a case. Um, I don't think that she's going to present a theory that has any chance of prevailing, but I think she will present a case. I think the reason she is so adamant about wanting to represent herself is because she feels like her lawyers weren't listening to her, that they weren't presenting the case that she wanted presented. This is a little bit different because, of course, we know what she said to Colby about the Idaho case, that there was no murder, that there was a suicide and accidental death and some sort of reaction to medication. Um, and she was not able to get her lawyers to make those arguments during the trial. Um, I don't know how she approaches this one because those things have absolutely nothing to do with Charles Vallow. Um, but I think there's every chance that she's going to just insist that it was self defense, that Alex felt threatened, and I think we're going to hear her testify. And I think That is probably one of the reasons why she wanted to represent herself, because her attorneys were have consistently discouraged her from testifying. So, Bad Lori had makeup on today and all through her court videos. I thought inmates weren't allowed to have makeup, or is this untrue? I think it really varies from jurisdiction to jurisdiction. I think that whether or not she's allowed makeup in the Maricopa County Jail, I don't know. The rules are different for different institutions. So I know that she asked for makeup in the in Boise in the Ada County Jail, and that was denied. But I have no idea what she is allowed in the Maricopa County Jail. And, we don't know what that's made of. Is it crayon? Is it Jolly Ranchers? Is it, we don't know what inmates are making makeup out of. But she does appear to have some amount of makeup on when since she's been in Arizona, the hearing she's appeared at. So I'm not sure what their rules are. Thank you for all your knowledge. I followed you since your first time on YouTube. Well, thank you so much. I appreciate it. It has been so much fun. It's been such a great journey. When I decided that I was going to write a book, I could have never anticipated what a great community that this was going to become for me, and and how much I was going to enjoy getting to know all of you. But I'm really glad that I did. I'm really glad that I started the channel, and I'm really grateful for all of you that show up and that miss me when I'm gone. That's super encouraging. So I want to thank you all for being here tonight, and thanks for joining us. Let's see, we have a few things we can talk about. My no knead bread recipe is still in the comments below if y'all want it. Definitely take a look at Ian Runkle. He is Runkle in the Bailey, I think, at the Bailey. I can't remember, but it's Ian Runkle, Runkle, and he is a lawyer in Canada. So he often has really interesting insight about the way the U.S. system appears to people outside the country, which I think is really fascinating. And he's a real expert when it comes to firearms because he does firearm law in Canada. So definitely take a look at his last video if you're at all interested in, sorry, if you are at all interested in his take on that New York City shooting, because he does a great job. Andrea Burkhart is still covering Kohberger and still recovering from covering the Delphi case. And if you have not had a chance to look at to watch her YouTube videos reporting from the Delphi trial, I highly recommend it. She takes extremely detailed notes and had a lot of real in the courtroom insight about jury reactions and reactions in the family. And her insights are really invaluable. Lawyer Lee was also there, and so was Bob Motta from Defense Diaries. So, but I really felt like Andrea had the inside scoop on what was really going on in the courtroom. So, and you can always find them in a YouTube search. Hi, Jane Blackbird. I'm currently enjoying your book very much. Any thoughts on your next one? Well, I have a couple of ideas that are kind of swimming around in my head. One likely will have some discussion of Delphi and Richard Allen and the investigation and the discoveries around that case. I also have a couple of other cases on my radar that might come from a completely different viewpoint, but still true crime. So the next book's going to be true crime. Just haven't quite narrowed down the field yet. But I did promise my agent a book proposal after the first of the year, so I'm going to get on that because I need to. Um, I need to really crystallize my thoughts around both of those books and see which one sort of gels. But stay tuned because you all will be the first to know. So I want to say thanks so much for being here. I hope you all have wonderful Thanksgivings. I'm incredibly grateful for you. I'm also grateful for Jen, our moderator, who, no matter when I say, "Hey, can you go live?" she's like, "Sure." So I'm super grateful that she's always willing to hop in, and I'm grateful for all of you. I'm am going to try and share some of my favorite Christmas recipes. Next weekend is going to be cookie baking for my family, and I will certainly start sharing some of our favorites. And I would love it if you would share your favorites with me. You can drop them in the comments, or you can email them to me. Our email address is also in the show notes. So I'm going to say good night. Thanks all for joining us, and I will see you next week. Good night.